Okay. This is the new judgments we have to draw. New judgments of instruction. These two judgments are highlighted. I had almost, I am at the end of my this one. No, minutes. One error I find in the art of the learned single judge. There's also in the differing view of is that, and that is also pleading of the petitioner's use. They want seniority to be determined on the basis of working strength. How it would differ is like this, Manoj. Suppose 300 is cadre strength, and actually only 200 people, 200 posts are filled up. Now, let us take a hypothetical example like this. 300 is the sanctioned cadre strength. Ratio is, or the quota is, 2/3 promotion, 1/3 direct recruitment. Suppose, as at a particular point of time, only 210 posts are filled up and 90 posts are vacant. Now, how many promotees have to get are within the quota? How many promotees are in excess of the quota? There are two alternates pleaded here. Alternates means conflicting provisions pleaded here. One is, suppose it is 210 is filled up. One way of looking at is, look, only 210 are filled up. 2/3 of it comes to 140. Therefore, promotees from 141 to 200 are in excess. That is one way of saying things. That is a model in which you would be taking working strength as the basis to determine the quota. Another model is sanctioned strength is 300, 210 are filled up, but quota has to be worked out only on the basis of sanctioned strength or full cadre strength. Therefore, though 90 posts are vacant, 200 being within the quota of 2/3, all 200 promotees would get seniority from the date of their promotion, notwithstanding the fact that 90 posts are vacant. These are the two models. Which of the two models is correct? Because I find that some High Court also has, while giving this calculation, has said, so working strength is this much, therefore quota is this much. My respectful submission is, where quota is linked to number of posts in the cadre, it is the sanctioned cadre strength alone that is relevant and not the working strength. Now, if my lords kindly take volume 3 of the compilation, not this judgment, citation is good. Cadre and recruitment. In this, my lords, the recruitment rules, if my lords would kindly take 1983 rules or whatever rules, my lords. Even the currently the 1983 rules, my lords would take 691, page 691. That is volume 3. Sorry, my, so I always forget that my lords have a different compilation.
Yes.
At 691, item 2 district judges, how the quota rule reads is like this. By promotion on the basis of seniority cum merit from the cadre of civil judges, provided that such number of posts as may be determined by the High Court from time to time, but not exceeding aggregate 33 and 1%, 1/3% of the posts in the cadre. It is linked to posts in the cadre and not working strength. And again, my lords, the as amended, if you come to page 704, which is more direct, no devious language or circuitous language. Page 705, quota is defined this way, manners. 65% of the total posts in the cadre. That is, quota is linked to total posts in the cadre, not total posts filled up in the cadre. It becomes relevant for the reason whether 32 is there or whatever, all the temporary posts, apart from all that. If the total number of posts in the cadre is taken into account, my respectful submission is all the promotees will be within the quota, all the direct recruits also will be in the quota. The fundamental flaw that was canvassed, unfortunately, the respondents did not respond on that proposition. They also sailed with that proposition. The correct position would be you have to take the cadre strength only. For that, I just rely on two judgments, my lords. First, my lords may take All India Judges Association. Though the rule has not been amended, it will make only a difference in so far as the rota is concerned. But in so far as quota is concerned, it would not make any difference. I will point out. All India Judges 3, that is at page 83 of my compilation of judgments in volume 1. The basis on which it advised, Supreme Court advised a particular method to be followed in fixing quota is that para 29 at page 106. Experience has shown that there has been a constant discontentment amongst the members of the higher judicial service in regard to their seniority in service. For over 3 decades, a large number of cases have been instituted in order to decide the relative seniority for the officers recruited from 2 different sources, namely promotees and direct recruits. As a result of the decision today, there will be, in a way, 3 ways of recruitment. The quota for promotion which we have prescribed is 50% following the principle merit cum seniority, 25% strictly on merit by limited departmental examination, and 25% by direct recruitment. Then they go to the roster. Then they say in the next page, just 2 lines above placetum B, the 40-point roster has been considered, and then R.K. Sabharwal, etc. Now, R.K. Sabharwal is invoked in this paragraph for 2 purposes. One is for fixing of quota, another for fixing of rota also. In so far as rota is concerned, there is no adoption of the rule. Therefore, rota has never been in 1983 rules or 2004 rules or even present rules also. Therefore, that is out of question. Insofar as the quota is concerned, this suggestion of the Supreme Court came on the basis of R.K. Sabharwal. Even otherwise, 1983 rules and 2005 rules, which I pointed out, the quota is linked to total number of posts in the cadre. In such case, how it has to be interpreted? Now, my lords may take R.K. Sabharwal, page 77 in volume 1. You will become master of all this by the time I conclude. Para 6 at page 81. The expression, could my lords get it? The expressions posts and vacancies often used in the executive instructions providing for reservations are rather problematical. The word post means an appointment, job, offer, office, or employment. A position to which a person is appointed. Vacancy means an unoccupied post or office. The plain meaning of the two expressions make it clear that there must be a post in existence to enable the vacancy to occur. The cadre strength, this is important. The cadre strength is always measured by number of posts comprising the cadre. There may be vacancies, but posts is cadre strength is the total post. Right to be considered for appointment can only be claimed in respect of a post in a cadre. As a consequence, the percentage has to be worked out. The rest of it is not. Concept of vacancy has no relevance in operating. That is not very relevant. Now, notice in B.K. Pavitra, which arose from Karnataka Seniority Act for Protection of Seniority Act for persons promoted on the basis of roster and reservation. In that, the argument, one argument that was advanced, I think state also advanced and then others also toward that line, that percentage should be worked out on the basis of working strength. That was rejected by the Supreme Court, saying that working strength has no relevance. For that proposition, they relied on R.K. Sabharwal. You may also take B.K. Pavitra, page 419 in volume 2. Para 108 of that judgment. This is B.K. Pavitra. This is B.K. Pavitra 2. (108) is at page 498. One of the submissions which has been urged on behalf of the petitioners is that quota has to be reckoned with reference to posts which are actually filled up on the working strength and not with reference to sanctioned posts. This submission is answered by the decision in R.K. Sabharwal, which holds that the percentage of reservation has to be worked out in relation to the number of posts which form part of the cadre strength. The Constitution bench, that para 6 extraction may be skipped. Similarly, in Nagaraj, the Constitution bench held, in our view, appropriate government has to apply cadre strength as a unit for the operation of roster in order to ascertain whether in a given class or group is adequately represented in the service. The cadre strength as a unit also ensures that upper ceiling limit of 50% is not violated. Further, roster has to be post specific and not vacancy based. Hence, the submission that the quota must be reckoned on the basis of posts which are actually filled up and not the sanctioned posts cannot be accepted. I am aware, my lord, there are certain judgments which have said R.K. Sabharwal is not applicable for seniority because seniority is a concept under Article 16(1), and R.K. Sabharwal was dealing with reservation, which is a concept under 16(4). They have, but then where the quota is linked to cadre strength, operation of the quota will have to be based on cadre strength, and that proposition would not change. More so when 2002 judgment itself in the All India Judges itself has referred to R.K. Sabharwal, number one. Secondly, in all the the recruitment rules from 1980, 1962 onwards, in so the district it is always linked to cadre strength, total number of posts in the cadre. Then, my lords,
Just 1 minute.
then, my lords, the whatever rule is made today, it will not affect the earlier promotees or earlier direct recruits because in All India Judges 3 itself, Supreme Court said for future, henceforth, and existing seniority will have to be protected. Then notice how they replace how the quota linked to cadre strength, how it works. Division bench of our High Court had a occasion to consider it in my lords ILR 1981. Huh? That is the first judgment, my lords, page 1 of volume 1. In this case, the question arose like this, my lords. Learned judge of this honorable court, Lordship Justice Ramajoyce, he had taken a view that where there is a quota rule and there is long time gaps between two direct recruitments or two recruitments, direct recruitments, what happens is there will be imbalance in the cadre. To overcome that, what the learned judge suggested was, if direct recruitment and promotion takes place simultaneously, no problem. Otherwise, this problem of discontent is there. Therefore, in the determination of seniority, replacement principle will have to be applied. That is, A vacancy caused by retirement or promotion or otherwise wastage of a direct recruit will have to be filled by a direct recruit. Similarly, a vacancy arising out of going out of one promotee has to be filled up by a promotee. This was the long and short of that replacement theory. The question before the division bench was, one of the questions was, when would the replacement theory apply? Whether it is applicable to all quotas or only to specific quota. Answer given by division bench of this court is that where the quota is linked to number of posts in the cadre, replacement theory will apply. That my lord should get at para 26 to 31 of the report, that is at page 10 onwards. Before that, the questions framed are at page 7, para 13. For the rival contentions argued from the rival contentions argued by the Learned Council in this appeal, the following questions arise for consideration. Question number 3, my lords member. For applying the ratio between direct recruitment and promotion to a cadre, should the number of promotees and the number of direct recruits who go out of the cadre, whether shortly after their appointment to that cadre or after considerable time, who do not join duty after issue of orders of direct recruitment or promotion, be included or excluded? Answer, my lords, para 21 onwards. Regarding question number 2, in para 8 of his order, the learned single judge has observed thus: the learned counsel for the petitioners also pointed out another serious infirmity in the annexure filed along with the memo, that is, for purposes of classifying the vacancies as between direct recruitment and promotion. According to the memo, the number of persons in whose favor orders of appointment had been issued during the concerned block period, either by way of direct recruitment or by way of promotion, have only to be taken into account. He submitted that the vacancies which were not filled up either by direct recruitment or by promotion during the relevant block period also should have been taken into account. Neither in the memo nor in the statement of objections, the state government has specifically stated that during the relevant periods there were no other vacancies other than those already filled up. In the absence of such a statement, it has to be held that classification of vacancies has been made merely on the basis of actual number of persons appointed by way of direct recruitment and promotion without taking into account the unfilled vacancies, and therefore the impugned seniority list has been prepared without a valid classification of vacancies at between direct recruitment and promotion. This was the finding of the learned single judge. The learned advocate general who contended that the learned single judge erred in holding that for the purpose of application of quota rule, the number of vacancies occurring in a cadre during a particular period should be the basis for classification of posts as between direct recruits and promotees. The learned advocate general maintained that for such purpose, what is material is the number of appointments actually made to a cadre and not the number of vacancies in that cadre, because the government is under no obligation to fill all or any of the vacancies in a cadre at any point of time or occurring during any period, and that it is open to the government to keep such vacancies unfilled. Para 23. The relevant parts of the Karnataka Secretariat Services, the services recruitment rules 1957, read as under. That part, my lords, may skip. Coming to page 11, if my lords would come to quota, deputy secretaries. A. 50% of the vacancies to be filled by promotion. B. The rest of the vacancies to be filled by officers of IAS or MAS, subject to the condition of not less than 4 posts are held by the former. Then, my lords, under secretaries also. Then all by the word used there, vacancies. Quota is linked to vacancies. Then, my lords, kindly go to question number 3. Question number 3 again, my lords may refer to page para 13 to exactly see what is the court question frame. For applying, for seniority, this will be this one. For applying the ratio between direct recruitment and promotion to a cadre, should the number of promotees and number of, that is a question I have already read. Now kindly come to question number 3, para 26. The learned single judge has held in para 15 of the order. Once a proper classification of and recruitment is made, vacancies arising thereafter out of a direct recruit appointed vacating the post should be made available only for a direct recruit, and the vacancy arising out of the vacating of the post by a promotee should be made available for a promotee only, and it should not be taken up for reclassification. This was the finding recorded. That was reversed by division bench, saying that it would apply only in case of quota linked to total number of posts in the cadre. I'll just take my lords to that. The correctness of the above proposition was questioned by the appellant, that is the state. It was contended for the state that all vacancies arising, whether on account of direct recruits going out of the cadre of assistants or on account of promotees going out of that cadre by death, retirement, resignation, further promotion, etc., should be filled by applying the quota rule. In other words, it was contended that the vacancy arising out of the direct recruitment going out of the cadre need not necessarily filled by direct recruit, and likewise, a vacancy arising out of a promotee going out of the cadre need not necessarily be filled by a promotee, and that all vacancies in whatever manner they arise, whether on account of direct recruits or promotees going out of the cadre, should be filled by direct recruitment and promotion in the ratio prescribed by the recruitment rules. The following illustration will bring out the rival points of view. If in a year 16 direct recruits and 8 promotees go out of the cadre of assistants by retirement, promotion to a higher cadre, resignation, dismissal, or removal, how should those 24 vacancies in the cadre of assistant be filled up? According to the view expressed by the learned single judge, 16 vacancies should be filled by direct recruitment and 8 vacancies by promotion, because the proportion between the direct recruitment and direct recruits and promotees has to be maintained in the cadre. According to the content of the state, 12 vacancies should be filled by direct recruitment and 12 vacancies by promotion, because the recruitment rules provide for a ratio of 50-50 between these two sources of recruitment. Which of the above two methods should be followed in filling the vacancies depend upon the rules governing a cadre. Such rules may provide that a cadre should always consist of direct recruits and promotees in a particular ratio. An example of such kind of rules is found in the Karnataka District Judges Recruitment Rules. The rule, sub-rule 1 of Rule 2 of those reads, appointment to the cadre of district judges will be made by promotion of persons in excess of in the Karnataka Judicial Service in the cadre immediately before the cadre by direct recruitment, provided that as nearly as may be 33 and 1/3% of the number of posts in the cadre shall be filled or reserved to be filled by direct recruitment. Alternatively, the rules governing a cadre may provide that while making recruitment to that cadre, certain ratio should be maintained between direct recruitment and promotion. Where the rules provide, such ratio between direct recruitment and promotion should be followed in making appointments to fill vacancies in that cadre, irrespective of how these vacancies arose, whether on account of direct recruits going out of the cadre or on account of promotees going out of the cadre. Then, my lords, assistants recruitment rules dated notice. Para 31 is the finding. Unlike the Karnataka District Judges Recruitment Rules, the Secretariat Recruitment Rules do not provide that as nearly as 50% of the post should be filled by reserved to be filled by direct recruitment. All that the Secretariat Recruitment Rules provide is that while making recruitment to fill the vacancies in the cadre, 50% of the appointment should be divided by direct recruitment and 50% by promotion. These rules do not provide that the vacancies arising out of direct recruits going out of the cadre of assistants should be filled by direct recruits only, and that the vacancies arising out of promotees going out of that cadre should be filled by promotees only, so as to ensure that the cadre of assistants always consists of direct recruits and promotees in the area ratio of 50-50. By implication, what this division bench said is, If the cadre strength is linked, if the quota is linked to number of posts in the cadre, then you can apply replacement theory, which gels with what was told subsequently in 1995, to be precise, 10th February 1995, with the Supreme Court in Arkasavarwal's case, where it said once the percentage is reached, percentage of reservation is reached, thereafter roster will cease to operate, and it is the replacement theory that will operate. The direct recruit going out will be filled up by direct recruit, and a promotee going out will be filled up by promotee. That is one of para 4 of uh, judgment in R.K. Sabharwal, page 77, the relevant paragraph where the Supreme Court spoke of replacement theory is at paragraph 5. At page 81. We see considerable force in the second contention raised by the learned counsel for the petitioners. The reservation provided under the impugned government instructions are to be maintained in each department. The roster is implemented in the form of running account from year to year. The purpose of running account is to make sure that scheduled caste, scheduled tribe get their percentage of reserved post. The concept of running account in the impugned instructions has to be interpreted that so that it does not result in excessive reservation. 16% of the posts are reserved for members of the SC backward classes. In a lot of 100 posts, those falling at serial number so and so have been reserved. Roster points 27 and 7 reserved for backward classes. It is thus obvious that when recruitment cadre starts, then 14 posts are to be filled among the members of scheduled caste. To illustrate, first point in the cadre has to be etc. etc. All that my lords may skip. My lords may kindly come to the last sentence there. In other words, in a cadre of 100 posts, when the posts earmarked in the roster for the scheduled caste and backward classes are filled, the percentage of reservation provided for reserved categories is achieved. We see no justification to operate the roster thereafter. The running account is to operate only till the quota provided in the impugned instructions is reached. Once the percentage is filled, the numerical test of adequacy is satisfied, and thereafter the roster does not survive. The percentage of reservation is the desired representation of the backward class in the state, and it consists of the demographic estimate. The numerical quota of course is not shifting boundary, but represents a figure with due application of mind. Therefore, the only way to assure equality of opportunity to the backward general category is to permit the roster to operate till the time respective appointees occupy the posts meant for them in the roster. The operation of the roster and the running account must come to an end thereafter. The vacancies arising in the cadre after the initial posts are filled will pose no difficulty. As and when there is a vacancy, whether permanent or temporary in a particular post, the same has to be filled from among the category to which the post belongs. For example, one type of riser, then slots are to be filled among the persons. By following this procedure, there shall neither be the shortfall nor excess of the percentage of reservation. But it said that replacement theory. Here, the quota is linked to number of posts. Replacement theory, and as long as even under the replacement theory, as long as the number of direct recruits or number of promotees occupied in the cadre is less than the total number of posts reserved for them in the cadre, they will get seniority from the date of their initial appointment. If they are in excess, their seniority will be postponed till the regular vacancy arises in their quota. Therefore, we are saying that block period is not made, or the number of vacancies are not classified. All those things will not apply. Now take the cadre strength and by applying incremental method, arrive at the total number of direct recruits that are permitted to be in cadre by applying judgment in High Court of Punjab versus State of Punjab, and operate the cadre, manage the cadre in that ratio so that the fixed number does not exceed. I have worked out and given as to on the days we were promoted and on the days they were recruited, what were the number of posts available for promotees. I have demonstrated that it is within the numbers permissible, total number of promotees in the cadre, that is applying judgment of the Supreme Court in paragraph 48, 49, which Haryana. Page 31, I have extracted the relevant paragraphs of page 31, my lords, of the synopsis, two paragraphs of Punjab and Haryana High Court that I have extracted. I have read it any number of times, my lords, from the book also. I would not like to. It cannot be, it is not that the effect increases by number of readings. Ultimately, what I read is important. Repetitions would not double the strength. Rather, it would decrease the intake because ಏನಿವರು ಇದನ್ನೇ ಓದ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ we try to dose off. May not be the other side. This side I have done that number of times. No, my lords. One of the prayers of the direct courts is that rule has not been amended. And I have also pointed out from the judgment itself of the Supreme Court in All India Judges 3, as also the subsequent judgment in AIR 2016, rendered in December, where the Supreme Court reiterated, henceforth rule shall be made and henceforth this shall be the procedure. No matter, no person is entitled to seek a writ to any employer, much less the High Court, that a rule shall be made in a particular manner. Because ultimately, recruitment, seniority, cadre strength, these are all matters of policy. Yes, Supreme Court can say something for that if they want to complain that Karnataka High Court has not amended the rule. Karnataka government has not amended the rule. In spite of judgment number 3 and in spite of judgment number 6, then it is a matter that has to go before the Supreme Court, where maybe invoking 142, they may say that you amend retrospectively, prospectively, what they say is irrelevant. Insofar as jurisdiction Article 226 is concerned, this court cannot direct making of a rule in a particular manner. For that proposition, my lords, I just would rely on judgment of the Supreme Court in the P.U. Joshi. That is for the proposition, my lords, that it is a policy matter. Para 10. at page 639, Manoj, para 10. We have carefully considered the submissions made on behalf of both parties. Questions relating to the constitution, pattern, nomenclature, cadres, categories, creation, abolition, prescription of qualifications, and other conditions of service. Seniority is a condition of service, including avenues for promotion and criteria to be fulfilled for such promotion, pertain to the field of policy is within the exclusive discretion and jurisdiction of the state, subject, of course, to the limitations and restrictions envisaged in the Constitution of India, and it is not for the statutory tribunals, at any rate, to direct the government to have a particular method of recruitment or eligibility criteria or avenues for promotion, or impose itself by substituting its views for that of the state. Similarly, it is well open and within the competence of the state to change the rules relating to service and alter or amend and vary by addition, subtraction, the qualifications, eligibility criteria, and other conditions of service, including avenues of promotion from time to time, as the administrative exigencies may need to the state. Like with the state by appropriate rules, is entitled to amalgamate departments or bifurcate departments into more and constitute different categories of posts or cadres by undertaking further classification. Bifurcation or amalgamation, as well as reconstitute and restructure the pattern of cadres categories of service as may be required from time to time by abolishing the existing cadres posts and creating new cadres posts. There is no right in any employee of the state to claim that the rules governing conduct should be forever the same as the one when he entered service and for all purposes, and except for ensuring and safeguarding rights or benefits already earned, acquired or accrued at a particular time. A government has no right to challenge the authority of the state to amend, alter, or bring into force the rules relating to even an existing service. Then, my lords, in Namita, in Namit Sharma, 2013 10 SCC 359. This is a case, my lords, where Supreme Court was reviewing its own judgment in the very same case, Namit Sharma. In the review order, this is what the Supreme Court held at para 36, page 386. In the judgment under review, in direction 108.5, the central government have been directed to frame all practice and procedure related rules to make working of the information commissions effective and in consonance with the basic rules of law and with particular reference to section 27 and 28 of the act within a period of 6 months. Section 27.1 and 28.1 of the act are extracted here and below. Power to make rules by appropriate government. The appropriate government may, by notification in the official gazette, make rules to carry out the provisions of this act. Power to make rules by competent authority. The competent authority, by notification in the official, may make rules carrying. The use of word may in section 27 and 28 makes it clear that Parliament has left it to the discretion of the rule-making authority to make rules to carry out the provisions of the Act. Hence, no mandamus can be issued to the rule-making authority to make the rules either within a specific time or in a particular manner. If, however, the rules are made by the rule-making authority and the rules are not in accordance with the provisions of the Act, the court can strike down such rules as ultra vires the Act, but the court cannot direct the rule-making authority to make the rules where the legislature confers discretion on the rule-making authority to make rules. In the judgment under review, therefore, this court made a patent error in directing the rule-making authority to make the rules within a period of 6 months. That power is not available to even to the Supreme Court under Article 32, and so also to the. Uh, then, my lords, one of the submissions I made was that the learned judge, in holding that 32 posts are in excess and therefore the seniority list is set aside, the only finding is given is temporary posts and 32 posts. Temporary posts also including 32 posts. He sets aside the seniority list, confirms the judgment of the learned single judge without arriving at a finding that the faults pointed out would give any relief to the direct recruits. Suppose, assuming those faults exist, in spite of those faults, if seniority of the direct recruit is not going to change, in the sense, if they are not going to come above the promoted district judges, seniority list cannot be set aside because it would amount to grant of a futile writ. And it has been the consistent practice of the writ courts that they would not issue futile writs. A finding has to be indicated. Suppose this 32 is removed. Where would the direct accrueds figure in the seniority list? Is it above all the respondent promotees? Or is it above none of the respondent promotees? Or is it about above a few of the promotees? This exercise is not done both by the learned single judge and also Lordship Justice Rai in the division bench. First of the judgments, my lords, were the concept of non-issuance of futile writ was invoked by the Supreme Court, was in K.N. Guruswamy's case. In K.N. Guruswamy's case, what had happened was that in the matter of grant of excise contract, this court had dismissed the writ petition, holding that it is a contractual matter, we don't want to interfere. Earlier days of the jurisdiction, we can't take really an exception to it. Supreme Court found fault with that judgment of the High Court, said that it is a statutorily awarded contract, therefore whether award of the contract was proper or not was amenable for judicial review. But then it declined to issue a writ, holding that though the petitioner came before the court in good time, now all that remains in the contract is a few days or a month and a few days. It will be futile even if you issue a writ. And this court will not issue a futile writ. That is not K.N. Guruswamy versus State of Mysore. That judgment is not readily placed here. I will supply it, my lords. My lords may kindly see K.N. Guruswamy. Thereafter, my lords, the question came in S.L. Kapoor, where the action of the executive was found fault with on the ground that it is contrary to natural justice. Yet Supreme Court declined to grant a writ. Holding at paragraph 17, my lords, at page 392. On merits, finding was given at para 17. And then last paragraph, para 17. Linked with this question is the question whether the failure to observe natural justice does not at all matter. If the observance of natural justice would have made no difference, they admitted or indisputable facts speaking for themselves. Where on the admitted or indisputable facts, only one conclusion is possible, and under the law, only one penalty is permissible. The court may not issue a writ to compel the observance of natural justice, not because it approves the non-observance of natural justice, but because courts do not issue futile writs. But it will be a pernicious principle to apply in other situations where conclusions are controversial, however, slightly, and penalties are discretionary. Then, my lords, para 26, 26 at page 395. In the light of discussion, we have no option but to hold that the order dated 27 February 1980 of the Lieutenant Governor superseding the New Delhi Municipal Corporate Committee is vitiated by the failure to observe the principles of natural justice. The question is, what relief should be given to the appellant? The term of the committee is due to expire on 3rd October 80, which means that just a few days more are left for the term to run out. If now the order is quashed and the committee is directed to be reinstated with liberty to the Lieutenant Governor to proceed according to law, this should be our order ordinarily. It may lead to confusion and even chaos in the affairs of the municipality. Sri Sorabji, the counsel for the appellant, had relieved us of our anxiety by stating, in view of the fact that the term expires on 3rd October, and as the appellant is anxious to have the stigma cast on him by the notification removed, the appellant does not trust either for reinstatement in office or for striking down the notification, so long as there is just determination of the invalidity of the notification. We have held that notification is vitiated with the failure to observe the principles of natural justice, and we let the matter rest there. We neither quash the notification nor reinstate the committee, nor are we to be understood as having expressed any opinion on merits of the supersession. We allow the appeal in the manner indicated. What this means for the present case? For the present case, it only means if the court finds any administrative error committed, court may advise for future what has to be done. But as long as the petitioners have not been able to demonstrate that they would steal a march over everybody in the impugned seniority list whose ranking is challenged, it cannot be a wholesale setting aside. If a limited jumping is probabilized by their case pleaded and case argued, to that limited extent it can be set aside, but not the entire list as has been done by the single judge and has been approved by one of the judges. Therefore, my lords, futile writ, of course, there are certain other judgments also I don't want to repeat. Only one last submission I would like to address, because this question troubles. The K.N. Guruswamy also has come. It is a 5-judge judgment, my lords. At para 20. At page 131. The next question is, whether the appellant can complain of this by way of a writ. In our opinion, he could have done so in an ordinary case. The appellant is interested in these contracts and has a right under the laws of the state to receive the same treatment and be given same chance as anybody else. Here we have Timmappa, who was present in the action and who did not bid. Not that it would make any difference if he had, for the fact remains that he made no attempt to outbid the appellant. If he had done so, it is evident that the appellant would have raised his own bid. The procedure of tender was not open here because there was no notification, and the furtive method adopted of setting a matter of this moment behind the backs of those interested and anxious to compete is unjustified. Apart from all else, that in itself would in this case have resulted in a loss to the state, because as we have said, the mere fact that the appellant has pursued this writ with such vigor shows that he would have bid higher. But deeper considerations are also at stake, namely the elimination of favoritism and nepotism and corruption. Not that we suggest that have occurred here, but to permit what has occurred in this case would leave the door wide open to the very evils which the legislature in its wisdom has endeavored to avoid. All that is part and parcel of the policy of the legislature. Nor of it can be ignored. None of it can be ignored. We would therefore, in the ordinary course, have given the appellant the writ he seeks. But owing to the time when this matter has taken to reach us, a consequence for which the appellant is in no way to blame, for he has done all he could to have an early hearing. There is barely a fortnight of the contract left. We were told that the excise year for this contract expires early in June. A writ would therefore be ineffective, and as it is not our practice to issue meaningless writs, we must dismiss this appeal and leave the appellant content with enunciation of the law. That is the thing, my lords. Therefore, my lords, I am not saying, my lords, I only said what the Constitution said, I brought to my lord's notice. I do not venture to say anything, my lords. All that I have said is bringing up appropriately on each of the issues covered what the Supreme Court has said. And in one or two cases, what has been the law in this state from almost times immemorial. For example, Chickbaswaya, 1981 vintage. Then, my lords, this C.V. Chitra, that was the earliest case filed in this court after implementation of the first National Judicial Pay Commission report by the Supreme Court. Therefore, my lords, all that I am saying is, yes, there may be some administrative, what I would say, I would not call them misdemeanors, I would call them deviations. But as long as they have not established to have had any impact on the ranking of the direct recruits in the impugned seniority list, it can only be improving the future, and it cannot be annulling the seniority. That is my respectful submission. I am grateful, my lords. In fact, when I entered this brief, I thought I would complete in 2 hours, but it has taken number of 2 hours. I am grateful to my lord's indulgence, and I. Huh? Just to? But I have not occupied all the 9 sittings. Sorry, I came only in third sitting. I came only in fourth or fifth sitting, if I remember. Because normally papers come to me only when they are in extreme difficulty, or they perceive that they are in extreme difficulty.
But I'm told the Honorable Court wanted me to assist in regard to one or two issues, my Lord, with reference to the records. I have the record, my Lord. If the Lord would like to peruse them now or. Please, please, please. I have, for convenience, my Lord, I have filed a memo which gives all the details. And I've also filed a written synopsis. Only one aspect, my Lord, which your Lordships wanted to see the original record, which was placed before the earlier bench, my Lord, was at which stage this committee went into it, and at what stage it went before the Honorable, all the members of the full court, and what the proceedings were. So to that extent only I have to place. They're all flagged and ready. I'll show it to NDM, Lordship. Please. Great.
It is better. I'm sorry for the interruption. It would be better if it demonstrates only so that any doubts that the
record is
may
there.
have.
Okay, there are two things. One is whenever there were after 2016 or just after 2018, whenever there were promotions, we would like to have a look at the administrative committee note.
Please.
The committee note.
That is there. It's flagged and kept ready.
So let us see what the petitioners say.
They can.
And then we come back.
Yes, ma'am. I have no objection, my Lord, for them to see it also. I mean, there's nothing.
So let them start.
Yes, yes, yes. Please, ma'am. Please, please.
Lord, there is a lot of inconsistent in the argument of the one of the appellants High Court and one of the appellants the private respondents. High Court takes a particular plea, not 83 onwards quota would apply. Kindly note it.
It is a specific stand.
It's the specific stand of the High Court that quota would apply from 1983. The private respondent who have not even filed reply, they are arguing in vacuum before this court. I don't know how it could be. Let them argue, my Lord. My Lord has given a full opportunity. But the question is, my Lord, this inconsistent plea may confuse this court. Lord, the 83 rules prescribe quota.
Was addressed, considered by the division bench, rejected.
Unfortunately, my Lord, the counsel for private respondent did not bring the notice of this court that he argued this question before the revision bench at para 19. Particular plea was raised. 83, there is no quota from 83 onwards till 2005. This was the argument addressed by the learned senior counsel for the in other case in 2014 law division bench of this court.
Very same plea was
Para 19 was specifically plea was raised. It was answered by the court in para 60 that 83 onwards quota would apply. So
there cannot be a second or third means. Very same.
same argument is addressed. Division may decline to decline this argument and held blood. Quota would apply from 83 onwards to third, one third. And High Court consistently pleaded before this court with division bench, yes, 83 from onwards quota would apply. Now, what is the rule holding the field in state of Karnataka judiciary is concerned, my lord? Kindly come to now the article Constitution of India. Now, Article 229 is the, my lord, recruitment to rules pertaining to the, my lord, officer servant of the High Court. 229. Kindly see, officer and servants and expense of the High Court. Appointment of officers, servants, High Court shall be made by the Chief Justice of the court or such other officer, a judge or officer of the court as he may direct. Provided that the governor of state may by rule requiring that in such cases may be specified in the rule, no person shall attach to the court shall be appointed to any office connected with the court save after consultation with the state public service, etc. This is not pertaining to employees of the High Court. Employees of the High Court. That has nothing to do with the recruitment to the post of district judge. But kindly come to directly come to chapter 6, article 233, which 233, 233. 233(1), appointments of a persons, kindly note it, Lord, to be, and posting, kindly note it, Lord, appointments to the a person to be, that means for direct recruitment, and the posting and promotion of district judge, kindly note, it applies to both direct recruitment, posting and promotion. Judges of any state shall be made by the governor of the state in consultation with the High Court, exercising jurisdiction in relation to such state. Then, my lord, 2, a person not already in service of the union or state shall only be eligible to be appointed as district judge if he has been for not less than 7 years as an advocate or pleader and recommended by High Court for appointment. There is no quota prescribed in 233. In A2 Rule 33, rules are changed by the governor, that means particular DPAR, Department of Personal Administration, in consultation with the High Court, prescribing quota. My lord, the private appellants, my lord, has taken a particular plea, my lord. Civil Court Act would apply, it will prescribe the catering, etc. My lord. Kindly come to Article 233, my lord, through to 36, interpretation. 233A is very important, my lord, and B, both by my lord, is very important, my lord. It defines the cadre of district judge. Kindly see, my lord. In the expression district judge includes judge of a city civil court, additional district judge, joint district judge, assistant district judge, Chief Judge of a small court, small class court, Chief Presidency Magistrate, Additional Chief Presidency Magistrate, Session Judge, Additional Session Judge, Assistant Session Judge. Right? Can a city civil court can apply law? When Constitution defines, according to him, only city civil court would apply. Nobody, nothing, no, nothing else. Constitution itself defines what is the cadre of expression of district judge. But condition B, the expression judicial service, not district judge case is not a judicial service. Only subordinate district judge is called judicial service. B, the expression judicial service means a service consisting of exclusively persons intended to fill to the post of district judge and other civil judicial post inferior to the post of district judge. Kindly note it. Judicial service means below the cadre of district judge. Now these are the provisions under the Constitution. Be expression what be what. Therefore, my lord, my submission to your lordship is, Lord, district judge is entirely different cadre. Is not a judicial service at all. Judicial service means only not a cadre below district judge. Cadre below district judge. Now, my lord, before going to the fact, my lord, I will not bring to the lordship's notice of Karnataka. What is the enactment made in the state of Karnataka as far as judiciary is concerned? Copy. But I am placing all the, notwithstanding the fact that I am for priority code is my lord. I am only, my lord, arguing the case, Lord, the law what law says. I do not want to bundle the case law which confuses the court here. Lord, Kandisi, the 1962 rules. First, this is the first rule, Lord, only recruitment to the post of district judge. Kandisi, Lord, page 3. Lord, this is a district judge entry level, Lord. Why I am making, Lord? There are 3 kinds of district judge post. District judge entry level, district judge selection grade, district judge super time scale. There are definition of that, Lord, I will come later on. This is the first time in 1962 appointment to the cadre of district judge shall be made, and is 2(1)(a) by promotion of persons of Mysore Judicial Service. Kindly note it, Mysore Judicial Service in the cadre immediately below the cadre of district judges, and by direct recruitment from the bar, provide that as nearly as may be 33 1/3% of number of posts in the cadre of district judge shall be filled or reserved to be filled up by direct recruitment. This is not. Then, my lord, the 2 promotion, appointment with promotion, sub-rule 1 shall be made on the ground of seniority merit from the cadre immediately below the cadre of district judges. 33 1/3 is the quota. Promoting is concerned, my lord, 66 2/3 in 62. But kindly come to next page.
Page 4.
Page 4. Rule 5. Right from the date of recruitment district judge, all rules in Karnataka state made by the under any law would be applicable to date of district judge. Right from 62. I will read the rule 5. Application of general rules. The provisions of the Mysore State Civil Service General Recruitment of 57 shall not be applicable in respect of recruitment judge under this kindly noted. Here they say General Recruitment 1957 has no application at all. Kindly come to rule 7. The important rule is 7. Right from 62. Except of the matters for which provision is made in this rule, the Mysore Civil Service 1958, the Mysore Government Servant Conduct to 57, the Mysore Government Servants Probationary Rules 57, Mysore Government Servant Seniority Rules 57, the Mysore Government Servant Medical Attendance Rules 57, and the Mysore Civil Services Classification, Control and Appeals Rules 57 for the time being in force, and all other rules, orders regulating the service conditions of the Office of the State Civil Service made under the Constitution shall be applicable to the judge appointed under these rules. That means to say, my lord, all rules made by the governor under 309 till the 78 Act is framed, all rules are applicable except, my lord, 57 general recruitment rules.
The other side, that Civil Services Act has no application. Is the contention raised by the respondents and maybe mailed?
The contention was raised by 1978 Karnataka Civil Service Act has no application. That all rules are made in state of Karnataka. When Act 19 till the 78 Act came into force, transitory rules were framed by the governor of the state. Kindly take now Article 309 of the Constitution. What is transitory rules? My lord, we kindly take 309. It is called transitory rules till the act is promulgated by each state of in India. Subject to the provisions of the Constitution, acts of appropriate legislature may regulate the recruitment conditions of service of persons appointed to public services and post in connection with the affairs of the union or any state. Kindly note it. Subject to the provisions of this Constitution, acts of appropriate legislature may regulate recruitment condition of service of persons appointed to public services posts in connection with the affairs of the union or the state, provided it shall be competent for the president or such person as he may direct in case of services and posts in connection with the affairs of the union and the post, and for the governor of a state or such person as he may direct the in services of the and post with the affairs of the state may make rules regulating recruitment and condition of services person so appointed to services and post until provision on this is made by or under an act of the appropriate legislature under this article. Any rule so made shall have effect to subject to the provision of any such act. Not all the rules framed under 309 of the Constitution, transitory rules, my lord. Karnataka state is concerned, it passed Karnataka Civil Service Act 1978. Though, my lord, it was passed, my lord, 1978, my lord, but received the assent of the president on, my lord, July 85. July 85. And you take the Karnataka Civil Service Act, my lord. Why I am making, because all the rules made 309 is deemed to be part of this rule till the rules are paid under this act. Kindly theme not preamble. my lord will find,
Even though the
whereas under Article 187(2), my lord got it, and clause 2 of 229, when I told my lord,
district judges.
the High Court employs 3 and Article 309 of the, and entries 3 and 41 of list 2. It is a state enact list blood under list 2, 7th schedule, entry 3 pertaining to the state list which can
Civil
not
service,
civil services. Any civil service state can enact the rules. Lord, list 2 of the 7th schedule of the Constitution of India, legislature of the state may by law regulate recruitment and condition of service of persons appointed to public services and post in connection with the affairs of the state of Karnataka and to secretary staff of the House's legislature and condition of service of officers and servants of the High Court of Karnataka. Then, my lord, 1 small a, 2 section 21a defines High Court. Then, my lord, clause 3, section 2(3) defines what is public service. Public civil service of a state includes civil posts under a state, secretary staff, house of the legislature, officers, or servants of the High Court. Then, my lord, section 3 regulates how to frame the rules. Lord, 3 and 8 is very important. 3 is with prior publication of 15 days, draft rules. 8 is Lord, promulgate the recruitment with the retrospective date. 3 is not promulgating the rules. Eight is retrospective effect of the rule. State has power to make rules, my lord. Section 8. I don't read, my lord, because section 8 itself says, my lord, 2 retrospective rule can be framed. To laying down before both the houses, rules can be given effective with retrospective date. Now, my lord, all the rules framed under 309 of the Constitution, my lord, is deemed to the rules made under this act. Kindly take section 3, Roman 3, Roman 1, Roman 2, my lord, got it? Section 3, section 3, subclause 3, Roman 1, Roman 2, Roman 3. Roman 3 is very important, my lord. All rules related to matters referred to in subsection 1 and in force from the date of commencement of this act. Kindly note it, my lord. I will now read only 3. Relating of this act made by the governor under the proviso to Article 309 of the Constitution of India, regulating the recruitment and condition of service persons who appointed to the civil services and post in the affairs of the state and made by the government under any law pertaining force shall be deemed to be rules. Kindly note it. Shall be deemed to be rules under this act.
Subsection 1.
And shall continue in force until they are modified or replaced by rules under this act. That means to say, my lord, all the rules framed in 309 of the Constitution is deemed to be, my lord, rule framed under this act and under this act until it is modified. Now, my lord, my learned friend, my lord, has said, MD Dikshit, all orders and executive order, court cannot promulgate. I mean, government has no power. They must make rules. My lord. Now, Dikshit principle is watered down. My lord. Kindly take, my lord, the rule section 3, sub clause 1. 6/5/2010, my lord. My lord got it.
In terms of 229,
Yes, my lord.
only for officers in
Ah,
service.
yes, my lord. Office of the head, not the district judge, not the district. I must make it very clear. But rules are framed by the DPAR in consultation with the my lord, High Court of Karnataka. But I am not saying, Lord, this rule, this act applies to framing rules for framing of rules. It is a barala. But the question is, all the rules framed under this act, Lord, are applicable to district judges, governing seniority and other matters,
Time bond.
granting time bond. All this would apply. Not for the recruitment, not for recruitment. But after recruitment, what is the, how they should fix the seniority? Everything seniority would apply. That's why division bench also says. Because by doctor of reference, by this rule would apply. I'm not saying 78 Act would apply to
District judges.
district judges. No. But all the rules framed
Under this act,
under this act are applicable to district judge cadre. In the matter of seniority,
pay fixation.
pay fixation, of course, central pay is there, my lord.
We are governed under the conduct rules.
And conduct rules, my lord. Where is the conduct rule? Conduct rule is, my lord, 77 now repealed by 21. Karnataka conduct rule 21 is now applies to all.
Suppose district judge is to be discharged, he should be discharged in the probation rules.
Visionary rule apply. Okay.
Yeah.
No doubt. ಮುಂದಿದ್ದು.
Probation rules.
For example, provisionary rules, my lord.
Yes.
For provisionary period of a district judge, direct equity.
He should be discharged.
How he should be discharged, my lord?
Yes.
While examining Dikshit's case, my lord, by this court, division bench, this court, section 31A was there. Kindly note that. Why the division bench of this court says, my lord, number of post and the abolition and, my lord, creation of post, lord, is only by way of amending the rules. Why it says so, my lord? Section 31A. Kindly note it. That was the rule at that time. In 2004. What section 3A says, my lord? 3(1) small a. Subject to the provisions of this act, state government may, by notification, make rules specifying the different categories they post in the different branches of public services of the state, the total number and nature of post in each category, and scale pay admissible to each such category. These are all by way of framing rules state has to promulgate. This was the interpretation given by in Dikshit case in 2004. This was amended, my lord, on 6/5/2010 by Act number 20 of 2010. Kindly take the last clause. My lord, what I don't know, amended provision is there, my lord. Section 3, my lord, 2, last provision, my lord. Is there, my lord?
Clause apply to rule specific number of nature of posts. 2010 amendment.
Right?
10 amendment.
Yes, my lord. But kindly see, provide further that nothing in the clause A. Clause A means section 3(1)A. Not shall apply to rules specifying the number and nature of posts. That means to say, state can not, by way of cadre strength is concerned, state can not, without framing the rules, can not create and not abolish the cadre. This was on not 6/5/2010. MD Dixit is no more good law in your this. Now, my lord, coming on hand,
rules ತಗೊಳ್ಳಿ.
kindly take now rules for in Karnataka.
Amendment has taken place in the year 1980.
Lord, 62 rules, Lord, came to be promulgated in Mysore Gazette on 16/11/1962. Page 3. Page 3 of the Lord, list of enactment and government orders. Lord, I read already Rule 7, Lord. What are the rules applicable to district judge cadre? I need not read again. Coming to 83 rules, Lord, when it came into effect, Lord, 38/1983, it was gazetted. Kindly note it, Lord. It repeals the Lord 1962 rules. This 83 rules. Lord, what is the 83 rule introduced, Lord? Kindly see, Lord, that rule 2. Why I am making this submission, my lord? By 83 rules, in 89, rule was amended, creating, my lord, district judge super time scale. Kindly note, my lord, cadre strength of 314, what they give according to them, it includes this, my lord, super time scale. Then, my lord, Supreme Court created one more post that is called selection grade district judge. I will come to that later on. It is there in the list of enactments. I'll come to that. Kindly see, my lord, 2. In reference to each category, post specified column 2, schedule below, the method of recruitment, minimum qualification shall be as specified in the corresponding entries in column 3 and 4 thereof. Number 1, my lord. 2. But 2 is, my lord, kindly see note, my lord, 2. When it is inserted, 2/7/89. So, in the recruitment rules, my lord, super times, district super time is created, not method is prescribed, not in 89. What does this say? By promotion, by selection from the district judges by the High Court of Karnataka must have put no at least 5 years service as district judge. That means to say, district judge entry level. He must put minimum 5 years service to occupy the post of district judge super time. But there is no quota fixed, my lord. I will come to that. Then 2 is, my lord. But district super time case promotion 5 years ಯಾರು ಅಂತ ಅವ್ರನ್ನ ಕೊಡ್ಬೋದು. ಬಟ್ ಇವಾಗ ಕೇಳಿದ್ರೆ ಸ್ಟ್ರೆಂಗ್ ಫಿಕ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಸೆಲೆಕ್ಷನ್ ಗ್ರೇಡ್ ಎಷ್ಟು ಸೂಪರ್ ಟೈಮ್ ಕೇಳಿದ್ರೆ 1196 ಬಂತು. ದಟ್ ಲಾರ್ಡ್ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಐ ಪ್ರೊಡ್ಯೂಸ್. ಇಟ್ಸ್ ದೇರ್ ಪಾರ್ಟ್ ಆಫ್ ದಿಸ್ ಎನಾಕ್ಟ್ಮೆಂಟ್. ಲಾರ್ಡ್ district judge is concerned by promotion on the basis of the seniority cum merit in the case of civil judge, provided that such number of posts may be determined by the High Court from time to time, but not exceeding aggregate 3313 posts in the case of district judge may be filled up by direct recruitment. That means to say, my lord, 33 1/3 quota is fixed from, lord, on 24/8/1983 onwards. There is no doubt about it. Till 83, my lord, same quota is operated. Kindly see, my lord, the law, the 83 rules, my lord. Lord, why I am saying this recruitment truth, Lord? I make it clear, Lord. Lord, cadre strength with respect to district entry level shall be, Lord, disclosed before this court to apply quota. Not, Lord, 314 total cadre strength, which includes, Lord, super district judge super time scale, district judge selection grade also. Because rule itself creates district judge super time scale.
Direct recruitment happens to the cadre of district judge, not super time scale. Promotion from senior division happens to the cadre of district judge, not huh? So
Yes.
As far as direct recruitment is concerned, district entry level only.
direct recruitment does not happen for
Direct it does not happen to super time scale or selection grade because both grade will be filled up as per not merit cum seniority. 15 plus 10, I will come later on. 15% is prescribed for selection grade, 10% for super time scale, as per the order of the Honorable High Court, Supreme Court. That I will come later. In High Court, what the DPR fixed the percentage also. Now, kindly see now.
senior division in the bar. Promotion happens to the cadre of district judge.
Promotion is permissible only to the district entry level, not super time scale, from the scale of senior civil judge.
Senior civil judge.
It cannot happen to super time scale, nor it can happen to selection grade. No. Where is the explanation of the High Court? High Court never disclosed this fact. Well, kindly come to know the application of other rules. Page 7. Rule 3. Clause 1 and 2. Subject to Article 233, 234 and 235 of the Constitution of India. Proviso to Rule 5, 6, 2, 6, 3, 8, 9 and 10 to 13 of the Karnataka Civil Service General Report 77. No, my lord. In 62, my lord, it doesn't apply. 77, 57 rule is repealed by 77 rules, general recruitment rules. Only certain provisions would be applicable, not all. Not all. Kindly note it. 5, 6, 2, 6, 3, 8, 9. Application of the rules, Malad. General recruitment rules 57 is repealed by 77 rules. 77 rules, Malad, general recruitment, only certain provisions, not all. Only, Malad, rule subject to Article 33, 34, 35 of the Constitution of India. Proviso to Rule 5, 6, 2, 6, 3, 8, 9, 10, 13. Karnataka Civil Service General Recruitment 77 shall, so far as not they are not inconsistent with these rules, mutatis mutandis apply to the recruitment district judges, civil judges, under these rules. If it is inconsistent with 235 or 234 blood, this will not apply. Any inconsistency that blood, the Constitution will prevail. Then, my lord, 2. All rules regulating service condition, service of the members of the state civil services made from time to time under any law, kindly note it, any law, underline it. Whatever rules promulgated under 78 Act is applicable. Or, kindly know, otherwise, or also, or, it further says, or proviso to Article 309 of the Constitution of India. So any rules promulgated under the rule That means in Karnataka 78 Act. Or proviso to Article 301 of the Constitution of India, subject to 233, 34, and 235 be applicable to municipal civil judges, district judges recruited, appointed under these rules. That means to say, my lord, all rules, seniority rules, probationary rules, everything would apply. Unless it is contrary to rule, Article 230, 34. If it is inconsistency, my lord, that will prevail. But Article 233 does not deal with the seniority or quota. Article 33 is very silent. Therefore, my lord, the government, in the concern Chief Justice, promulgated the recruitment rules in Karnataka. But kindly see now, page 8, repeal and saving. Why I am bringing your lordship notice, my lord? 62 onwards quota would apply in Helicon. Kindly see rule, repeal and saving. Karnataka district judge recruitment to 62. Civil judge recruitment 66, municipal recruitment 81. Rules, all rules based on subject are hereby repealed. By 83 rules, my lord, 62 rules, all other rules are repealed. Then, my lord, page 15. That means to say, my lord, Karnataka civil service rules would apply to having regard to the judicial cadre also. Seniority rules would apply. Provisional rules would apply. But not all provisos of the general recruitment rules. For example, my lord, Rule 18 of the general recruitment rules fixes 15 days time to report for duty that recruitment takes place. If he does not report for duty, appointing authority can allow time, but he would lose his seniority. And his appointment also will be cancelled if the time is not allowed. But whereas judicial appointment is concerned, Rule 18 has no application. They have to report for duty, time fixed under the appointment order. Rule 18, therefore the rules, the proviso says all rules of general recruitment would not apply. As for reporting duty and time is concerned, whatever time fixed under the appointment order, they have to report for duty. Otherwise, appointment order will be cancelled. But general recruitment rules also deemed to be a law under 78 Act. Karnataka seniority rules also deemed to be a law under 78. Karnataka provisional rules also deemed to be law under 78. Karnataka general conduct rules 77 also deemed to be law under the 78 Act. Karnataka general civil services conduct rules 21 also deemed to be law under 78 rules. Because there is no other law which governs in Karnataka. It is only 78 Act, all rules are promulgated. Now, coming to the cadre strength notification, why I am making this submission? Lord, what is cadre strength? Would it include temporary post? Would it include only permanent post? Lord, now I read this, then come to provisions of KCSR, Karnataka Civil Service Rules. What is cadre strength? Temporary post includes or not? My Lord will certainly say about having regard to the provisions of KCSR. Lord, page 15. But this 2001 notification was issued, but by the DPAR, kindly see, my lord, note it. By order of the governor, by order in the name of the governor, not DPAR. But why DPR issues, my lord? I will come, my lord, to the rules and regulations in Karnataka state. Rule framed under 166(3) of the article. But kindly see here, government order dated March 2001,
The 3rd March.
3rd March 2001, in supersession of the all existing orders, Government of Karnataka hereby sanctions establishment of the state service cadre for district judge in the Karnataka judicial service. Strength of the said cadre, number of character, a post born in thereon shall be as follows. District judge, kindly note, super time scale. District and session judge, super time scale. Right? Total permanent is 20. It is a separate cadre, my lord. Cadre must show that. 2. District judges. District judges means, my lord. District and session judge means, my lord. It is entry level cadre. Kindly note it. But cadre strength will consist of both temporary and, my lord, permanent. Then, my lord, both it shall be counted for the purpose of, my lord, working out quota. If cadre strength shows, my lord, notification shows both temporary and, my lord, permanent, then, my lord, no way it shall be worked out, my lord, as per the cadre strength notification. No, my lord, kindly see. 33 plus 2 leave reserve. This is called temporary post. Kindly note it, my lord, column 4. My lord, got it, my lord, there. Column 5 is deputation reserve.
23.
23, my lord. My lord, kindly see, my lord. 33 plus 2 is permanent. 33 plus 2 is permanent, my lord. 23 is, my lord, both deputation reserve. Totally 46. Kindly see the pay scale, my lord. Why I am making this submission? District judge entry level is different pay scale. District judge super time scale is, my lord, different pay scale. It's a promotion.
Then 4,000.
My lord will find the pay scale of a lord district and session judge super time scale, lord, at that time, lord, 5825 to 6800, 6800. District judge entry level is 4700 to 6400.
400.
That means to say, my lord, rule also says super time scale. Rule 83 rule also says super time scale. Those who have completed entry level 5 years service. Cadre strength also shows, blood, district and session judge super time scale and district judge session judge entry level. Both are, blood, part of the cadre strength.
So I am repeating, for the purpose of calculating grade strength, entry level of ST judge is to be taken into consideration.
And why I am making my stand very clear. High Court has to work out the quota only for cadre strength under district judge level, when level district and session judge entry level cadre, not for super time scale or selection grade. No, my lord. What is cadre strength under the KCSR rule, my lord? Because rules framed under KCSR, Karnataka Civil Service rules would apply. Because 83 rules also says, clause 3(2), all rules framed under under any law or rules framed under 309. 309. Prior to 78 Act, plot, I showed your lordship 309 is the article. Transitory rules will be framed by the government of Karnataka. No, my lord, rule.
The district judge's pension is settled under KCSR.
But pension, everything will be settled under the KCSR only. Length of service will be the not settle the pension. Last pay drawn.
Last pay.
Where do you get it? How do you settle the pension? 50% last pay drawn. Where do you get? Only, my lord, under the Karnataka Civil Service rules. Nowhere else. Now, my lord, rule 8 KCSR, my lord. 11.
ಎಂತದ್ದು?
Kedar 10th.
ಕೇದಾರ ಅಷ್ಟಿದ್ದು.
Kedar. Yes. Lord, rule 8. Lord,
Clause 7.
subclause 7, my lord. My lord, got it? Cadre means strength of a service or part of a service sanctioned as a separate unit. Kindly note it, my lord. Strength of service, part of service sanctioned, important is sanctioned as a separate unit. There must be, Lord, notification sanctioning the cadre strength. Then, my lord, what is temporary post? Because I am not saying, my lord, quota would apply based on vacancy. Recruitment rule itself says quota would apply based on post only, post based, not vacancy based. I am not disputing that. The recruitment rule says so. My lord, what is not permanent post? What is temporary post? Because cadre strength may be of permanent post. If it, notification defines both, it will include both. Otherwise, not only permanent post. What do you mean by permanent post, my lord? Rule 8, subclause 33 defines 34 defines permanent post. Not got it? Not permanent post means post carrying definite rate of pay sanctioned without limit of time. Kindly note it. Without limit of time. Then, my lord, what is temporary post? It's also defined under Rule 846. 46. Not got it? 46, not? Sub, rule 8, subclause 46. Not? Temporary post means post carrying definite rate of pay sanctioned for limited time. Limited time. For example, Murad, Dandupalya, Murad, inquiry for holding not session for Dandupalya, for holding Murad a trial for Jayalalitha. There is a limit only 1 year with the thanks of the finance department. Then, my lord, rule 49 defines what is, my lord, temporary post. Temporary post. Note 2, my lord. Rule 49, KCSR. Note 2 defines what is temporary post. Rule 49. Why I am making this submission, my lord? There, my lord, what is temporary post? In two definitions are there. 49, Lord, note 2. Lord, got it? Temporary post may be divided into two categories. Post created to perform ordinary work for which permanent post already exists in a cadre, the only distinction being that of New posts are temporary, not permanent. Isolated posts, kindly noted, isolated posts for performing the special task unconnected with the ordinary work which service is called upon to perform. Holding up a trial of Jayalalitha is a particular purpose. That court will not take up any other cases. Holding up a trial of Dandupalya. Purpose is over, blood. What has ceased to be in existence? Once the purpose of the achievement of the court is over, that court ceases to be in existence. Lord, now the All India Judges, Lord, 2002 Supreme Court, Lord, is very clear, Lord. No. Now, Lord, 2005 rules are promulgated. Page 16. Page 16 in the Lord got it. Kindly see the preamble. Whereas draft of the Karnataka Judicial Service Recruitment of 2004 was published, required under section, clause A, subsection 2, section 3, read with section 8 of the Karnataka Civil Service Act 1978, Karnataka Act of 1990 by the High Court of Karnataka, notification dated so and so, 2004, in the official gazette 22/7/2004, part Roman 4A of the Karnataka Gazette, inviting objections, suggestion from all persons like to be affected. Rules are published.
We'll continue. The tentatively, the next date will be Tuesday. Tuesday, tentatively. It will be confirmed by the court officer, but you can block the date. Upon confirmation, it will be Tuesday, 2:30.
Tomorrow.
Next Tuesday. Next Tuesday at 2:30.
24th.
24th.
Yes, 24th. Tentatively, it will be
Possible,
confirmed.
but Friday or Saturday, because Saturday is also working day.
There is some
I leave to the court, but
Okay,
you
there
know
is-
how
there is
courts
some-
are placed.
Okay, there's some difficulty. So 24th at 2:30. The
Yes.
argument senior counsel Shri P.S. Rajgopal has concluded his arguments. For further argument, full stop. Learned counsel senior counsel Shri M.S. Bhagavat has commenced his arguments. For further arguments, matter is adjourned. Date will be intimated.
ಇನ್ನೊಂದು ಅದು ಹನ್ನೊಂದು ಕೊಡು.
ಕೊಡುವ ಇದು ಮುಗಿದ್ಮೇಲೆ ಕೊಡೋಣ. Next go. ಅಂತ